know my body cam is on. What happened?
I was turning here and I just swerved off. But you want to know something?
What?
I'm not answering your question. Am I under arrest?
Well, you're being detained right now. Will you submit to a breath test?
Officer, am I under arrest?
Have I answered that question?
Am I under arrest?
Didn't I just answer that?
Am I under arrest?
I already answered that.
On December 17th, 2025, officers in Washington state responded to a single vehicle accident involving a driver showing signs of intoxication. The footage raises 5 distinct legal issues: lawful detention, probable cause, Miranda timing, implied consent compliance, and juvenile advisement.
Hey?
Yes, I'm fine.
Alright, give me 1 second. 2King23, do you have a plate? Was it just you in the car? You called? Hi. Okay, just letting you know my body cam is on. What happened?
I was turning here and I just swerved off.
Where were you turning from?
From here.
From right here?
Mm-mm.
Which direction were you going?
I'm coming this way.
So
I was in that lane and this lane come up.
So you were going which direction? You were coming southbound? And you were in what lane? This
Middle.
one? Middle?
Middle.
Where were you turning to?
Into that lane.
Why were you turning into that lane?
Because I'm trying to make that light.
So were cars backed up over here?
No.
Why did you come into that lane so early if cars weren't backed up over here?
You know what? Don't with me.
No, I'm
seriously.
just no, ma'am. Hey,
No.
you need to stay here, okay?
No, seriously.
I'm only just trying to figure out what happened.
I was trying to make a turn.
Okay,
And this guy came up on me.
front head on with you. Do you have your ID on you?
Yeah, I have all of that, but you want to know something?
What?
I'm not answering your question.
All right. Well, you're not free to leave. Come here, ma'am. 2King23. She's walking away from me. Ma'am. Ma'am. Stop.
No.
Stop. Stop.
Hi.
I know you're gonna be detained, okay?
What's going on?
Am I under arrest?
Well, you're being detained right now.
Okay.
Yeah.
All right. Let's walk over here over to my car, okay?
Yeah, no, I'm not doing that.
You had your hand on it. I just
No,
want to make sure there's nothing in there that's gonna harm my partners.
Yeah, no, thanks.
Okay. So you have the right to remain silent. Anything you say can be used against you in a court of law. You have the right at this time to talk to a lawyer and have him present with you while you're being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you for question if you wish. You can decide at any time to exercise these rights and not answer any questions or make any statements. Do you understand these rights?
Thank you.
Ma'am, do you understand your rights? Okay, we're gonna walk up to the back of the vehicle. Turn to the, what are you doing? What are you doing? What's going on? What's happening? What is this right now?
Are you arresting me?
Yes, right now you're under arrest.
Under Terry versus Ohio, decided by the Supreme Court in 1968, an officer with reasonable articulable suspicion of criminal activity may detain a person for investigative purposes. That person is not free to leave. The subject's attempt to walk away mid-investigation did not terminate the detention it legally justified, escalating it. At the moment of physical interception, the officer possessed reasonable suspicion on 3 independent grounds: a single vehicle accident, the subject's own admission of driving, and observable behavioral indicators consistent with intoxication. The officer's statement "you're being detained, not under arrest" is a legally meaningful distinction. Detention requires only reasonable suspicion. Arrest requires probable cause.
Yeah.
Okay.
Yeah.
Give me release
it.
one here.
No, is there a way that we can just... All right. I would really prefer to not cut your bag. Okay, so I'm going to take you out of handcuffs for a second, but I need you to be chill. If we're not going to be chill, I'm going to have to cut your bag.
You're
Okay?
yelling in my ear.
I'm not yelling.
Yelling.
You're yelling right
Fine.
now.
Okay, good.
Oh. All I'm asking is that you just be cool while we take you out of handcuffs for a second.
Well, you just get really... You're disgusting.
Well, that's not very nice.
You're not very nice.
Why am I? You don't even know me.
Get me out of these handcuffs.
No, you're under arrest right now. I'm not taking you out of handcuffs.
I don't really give a shit.
Okay.
You gotta hold on her.
Yeah, I do.
Do you have extra gloves in your
You
car?
gotta hold on
You
me.
do? Where at?
Okay.
I have them in my pocket if you need.
What pocket?
It's in my side pocket in the back part of it.
Well, you can spread
Ma'am.
my leg.
Ma'am. Oh, I got them right here. Hey.
Oh.
Oh, here we go.
Back pocket.
Here
There you
we go.
Thank you.
Here we go.
Yeah, stop. Please
Stop
stop.
it, you guys.
Do you have anything on you that's gonna poke, stick, cut, hurt me at all? I would really prefer that you answer that. It's a simple question, that's all. I just want to make sure that I don't get stuck with anything. Do you have a shirt on underneath your jacket? Sweatshirt? Do you have anything else on you?
Did you search her?
He's searching her.
Okay. She going in your car?
Yeah.
Do you want to search her to confirm?
Okay. Yeah. If she's gonna come with me, I'll do the search. Finish up. Okay.
Getting wine drunk on a fucking Wednesday
anything in your
evening? Hell
pockets?
yeah.
Anything in your pockets, ma'am? Nothing that's gonna stick or poke or anything like that.
So right now you are under arrest for DUI, okay?
Okay. You got it real quick. I'm gonna do the, ma'am. See the back of my hand? I'm gonna be doing a groin sweep. Okay.
You the witness?
Yeah. I'm not so much witness. Let's
Okay.
leave me out of the witness as far
Okay.
as seeing it happen. I'm jogging down the other side here,
Yeah.
and she's getting out right after she went in, and she's basically gets up, and I go, "Are you okay?" Actually, she was right actually on the other side, so she probably got back. Just I don't know what she was doing, but
Like she was on the passenger side?
she's on the passenger side. Yeah, passenger side. So I'm running by, but her door was open. I'm pretty sure on the driver's side.
Okay.
So I asked what happened. She goes, "I'm going into the ditch," and she kind of started like giving me a hug, like oh, thank you. And then she started walking out into the lane of traffic, and it's like, no, let's go back over here. Let's not worry. She just didn't seem with it, and I could smell what seemed to me the best of my alcohol.
Okay.
And then I just kind of followed her. She was walking through the kind of.
So you never saw the
didn't-
car go into the ditch?
No, I can't be
While
a
you were
witness
on your
saying-
run, you
Right.
saw her in the passenger side,
She told me
and then she
she
told you that she was driving?
She was driving.
Okay.
Miranda warnings were first administered prior to formal arrest declaration. Under federal doctrine, this is permissible as a prophylactic measure. It does not invalidate the advisement or create timeline ambiguity that benefits the defense. Under Berghuis versus Thompkins 2010, Miranda protection is not triggered by silence or evasion alone. Invocation requires an unambiguous, affirmative assertion of the right to silence or the right to counsel. Asking "Am I under arrest?" is a question, not an invocation. It has no operative legal effect under Fifth Amendment doctrine. The interrogation may continue until an explicit invocation is made. Formal arrest was supported by probable cause under Washington Revised Code Section 4661-502, driving under the influence, and Section 4661-504, physical control of a vehicle while under the influence. Probable cause at the time of arrest rested on 4 pillars: the subject's admission of driving, behavioral indicators of impairment, a civilian witness corroborating the admission and the odor of alcohol, and the physical evidence of the accident itself. The pat-down search incident to arrest is authorized under Paul Chamel v. California, 1969, and affirmed in United States v. Robinson, 1973. No warrant is required to search the person of a lawfully arrested subject. Confirming the absence of sharp objects before reaching into the bag pocket is consistent with both the search incident to arrest doctrine and standard officer safety protocol.
Why are you being such a little meanie pants right now? Hey, have a seat in the car.
Go ahead,
I'd
ma'am.
love to.
You want the key to go with the vehicle or her? The vehicle. So you have the right to remain silent. You have the right at this time to an attorney. Anything you say can and will be used against you in a court of law. If you're under the age of 18, anything you say can be used against you in a juvenile court prosecution for a juvenile offense, can also be used against you in an adult court criminal prosecution if the juvenile court decides that you are to be tried as an adult. You have the right to talk to an attorney before answering any questions. You have the right to have an attorney present during the questioning. If you cannot afford an attorney, one will be appointed for you without cost if you so desire. You can exercise these rights at any time. Do you understand these rights?
Shut my door.
Is that a yes? Or a no?
Shut my door.
I got more stuff to read you. I'm sorry. I do. I'm sorry. I'm doing my job. Why are you so angry? I feel like we've been nice to you, and you're just yelling a bunch. I don't know why. Alright, so warning, you are under arrest for RCW 46.61.502 or RCW 46.61.504, driving or being in actual physical control of a motor vehicle while under the influence of intoxicating liquor and or drugs. Further, you are now being asked to submit to a test of your breath, which consists of 2 separate samples of your breath taken independently to determine alcohol concentration. Your driver's license, permit, or privilege to drive will be suspended, revoked, or denied.
Officer, am I under arrest?
Yes, you are, ma'am.
Okay, so shut my door. Thank you. Shut my door.
Remember how I just said I gotta read you something?
You've just told me.
Your
I'm
refusal to
under
submit to this
arrest.
test may be
Shut
used in a criminal
my
trial.
door.
You are further advised that if you submit to this breath test and the test is administered, your
Officer,
driver's
am
license,
I under
permit, or
arrest?
privilege to drive will be suspended,
Officer,
revoked, or
am I
denied
under
by the Department of
arrest?
Licensing for at least 90 days
Officer,
if you are
am
age
I
21.
under arrest?
Did I just answer that question?
Officer, am I under arrest?
Did I just answer that question?
Officer,
Ma'am,
am I under arrest?
did I just answer that?
You're not even asking me. Officer, am I under arrest?
I just answered that. Do
Officer,
you remember what I just said?
am I under arrest?
So remember about 30 seconds ago when you asked me
Yeah,
that.
and
what did
remember
I
about like
say?
30 seconds ago, I'm asking you if I'm under arrest?
Yep, I do remember that. And do you remember
Then answer me.
Do you remember what my answer was? Because I already answered you. I've already answered you twice, actually.
Shut my door.
No, because
Shut it.
I got to read you some more stuff. Why are you being such a meanie pants? You're being a meanie pants McGee right now, and I don't know why.
Oh, what?
A meanie pants. Yeah, I said it. Yep, I said it. I did. I know. I feel like we're 2 adults. We can just talk to each other. But you're yelling at me,
Shut the door.
being rude,
Shut the door.
asking me questions over
Shut
and over.
the door.
And remember how I just said I gotta read you some stuff? I'm gonna keep reading you some stuff, and then I'm gonna close your door, okay? If your driver's license, permit, or privilege to drive is suspended, revoked, or denied, you may be eligible to immediately apply for an ignition interlock driver's license. You have the right to additional tests administered by any qualified person of your own choosing. For those not driving a commercial motor vehicle at the time of arrest, if your driver's license is suspended or revoked, your commercial driver's license, if any, will be disqualified. Will you submit to a breath test?
Officer, am I under arrest?
Have I answered that question?
Am I under arrest?
Didn't I just answer that?
Am I under
I
arrest?
already answered that.
A second Miranda advisement was administered upon transport. The juvenile-specific version required under Washington Revised Code Section 1340-140. Washington's Juvenile Miranda statute mandates separate advisement when a subject may be under 18 years of age, including the provision that statements may be used in both juvenile and adult court proceedings. Failure to deliver this advisement exposes any subsequent juvenile court proceedings to a suppression motion. The officer's compliance here is procedurally critical, not optional. Washington's Implied Consent Law Revised Code of Washington, Section 46-20-308, requires the full Implied Consent Advisory be read before a breath test may be lawfully requested. Failure to complete this reading in full results in suppression of test results and may render the refusal itself inadmissible. The officer completed the advisory without omission. The subject's non-response to the breath test question constitutes a statutory refusal under RCW 46-20-308. This triggers 2 immediate legal consequences. First, mandatory license suspension by the Department of Licensing. Second, the refusal is admissible as circumstantial evidence of consciousness of guilt in any subsequent DUI criminal prosecution. The Supreme Court confirmed in Birchfield v. North Dakota, 2016, that breath tests incident to a lawful DUI arrest require no separate warrant. Refusing carries evidentiary consequences the subject likely did not anticipate. The subject was charged with 3 offenses: driving under the influence under RCW 46-61-502, reckless driving under RCW 46-61-500, and obstructing a law enforcement officer under RCW 9A-76020. At the time of this analysis, the disposition of criminal proceedings and any civil action remains unknown. The breath test refusal will be presented to the trier of fact under Washington's Implied Consent Evidentiary Rule. The primary arresting officer receives a B+. She correctly distinguished detention from arrest under Terry, completed the Implied Consent Advisory in full under sustained verbal obstruction, and administered Miranda prophylactically, all legally defensible decisions. 2 deductions apply. First, verbally considering the removal of handcuffs to free a bag strap contradicts officer safety protocol. Department shears exist for that purpose. Second, use of informal diminutives toward a potentially juvenile subject in custody is unprofessional and creates civil liability exposure, even where no Section 1983 claim would likely succeed. The backup officer receives an A-. His correct administration of the Juvenile Miranda advisement under RCW 1340-140 is the most legally significant individual action in this footage. The minor deduction reflects post-arrest casual commentary, while the subject remained in audible distress, a professionalism concern, not a legal violation. The subject receives a C. She possessed enough awareness of her rights to ask about them repeatedly, but never exercised them in a legally operative manner. Asking, "Am I under arrest?" is not a Fifth Amendment invocation under Berghuis. Her initial admission is a spontaneous, voluntary statement, fully admissible at trial, under the exceptions established within Miranda v. Arizona itself. Her sustained verbal obstruction during the implied consent reading directly generated the obstructing justice charge under RCW 9A 76-020, a charge that would not exist absent her own conduct. Her refusal of the breath test was a statutory right. However, that right carries immediate evidentiary and licensing consequences. Exercising it without understanding those consequences is not a legal strategy. 3 lessons from this encounter. First, silence is not enough. Under Berghuis versus Thompkins, the right to silence must be explicitly invoked. Passive non-cooperation does not halt questioning, it only expands legal exposure. Second, implied consent is not optional. Washington's refusal statute is constructed so that exercising the right to refuse still generates admissible evidence against you. There is no cost-free option once a lawful DUI arrest has occurred. Third, juvenile advisement is a legal obligation, not a courtesy. Officers who fail to assess age and administer the appropriate advisement risk rendering an entire interrogation constitutionally defective. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to subscribe to our channel for more content on police court interactions.